Hello, everybody. Sorry for the delay. We were having some issues with the computer, but hopefully everybody can see and hear me now. My name is Chen. I'm an employment lawyer with our firm's Vancouver office. I'm doing a live Q&A for the next 10 or 15 minutes or so. Hopefully some of you guys stuck around. And if you have any questions, put in the text box in front of you. I'll do my best to answer, but any and all questions related to employment law, if you're having issues with your boss, issues with a contract, if you've been let go, if you've been part of a mass layoff, anything, and I'll do my best to answer on here. Again, I'm sorry for the delay, but I'll do my best with the time we have. So we've got our first question here from Helen. So a manager put an employee in a performance improvement plan and fired her. Contents of the PIP contradict the company's policy. A young male replaced her, age 55. Is WorkSafe BC or HRT a good solution for reinstatement? Yeah, Helen, that's a good question because it raises a number of issues. Well, the first issue is severance, right? And then the second issue, as you've mentioned, is reinstatement. So WorkSafe BC deals with bullying and harassment in the workplace, right? And if you raise an issue that your boss is harassing you or bullying you, calling you derogatory names and yelling at you and stuff like that, that's something you could take to WorkSafe BC. And it's called a prohibited action complaint, right? If you've raised this issue that someone's harassing you and they fired you because of it, then that's the path you would go for reinstatement, okay? It doesn't sound like, well, I could be wrong, but from your brief description, it doesn't sound like that's an issue here. The issue is the performance improvement plan. So the Human Rights Tribunal is something that could be possible in the situation, right? And obviously, it sounds like this female employee, 55 years old, was replaced by a younger male employee. And as you probably know, Helen, the two enumerated grounds under the Human Rights Code, you can't discriminate based on age, and you can't discriminate based on sex or gender, right? And so those, if you can prove, if an employee can prove that the age or their gender was a factor in terminating their employment, then the Human Rights Tribunal has the power to order reinstatement, okay? It doesn't have to be the main reason, okay? So cases have gone before the tribunal that have tried to figure out what's the standard, right? Like, what's the standard you have to meet to prove discrimination? And the standard's not terribly high. You just have to prove that the age was a factor, not the main reason, just one of the reasons, right? It could be performance. It could be, you don't get along with some other people, whatever. But if you can prove that the company used age as a the basis, as one basis to let you go, that's discrimination. Same thing with if they let you go because you're a woman, right, or because you're a man. And so proving that is another thing, but it's you have to come up, generally you have to come up with more evidence in the fact that they replaced you with a younger male, right? There has to be, some evidence could be a pattern of them doing this, right? Or maybe sometimes, some employers put it in an email or in writing, right? They send an email to the manager saying, I want this person let go because, I want to replace them with a younger, male person. And so it oftentimes in human rights claims comes down to to proving the discrimination, which sometimes is tough. And so I think in that situation, Helen, it's a human rights tribunal matter. The third avenue that I see is a claim for severance, right? A severance you pursue through a civil court, so not a tribunal, but through a lawsuit. It's very difficult for an employer to let someone go because of poor performance and say it was just cause. Okay, the standard is very high. You basically have to prove that you've given this employee every chance to improve. You've given them mentoring. You've set objective, reachable goals. And from what you're saying, if the PIP contradicts company policy, that's obviously an important factor that helps the employee's case. And so, if you're 55 years old, your severance will tend to be higher than someone who's younger. So that's the third issue I see here, Helen, is that the issue of, besides the issue of reinstatement, this person is probably entitled to severance pay. And if they're 55, if they've been with the company for years and years, some employees have gone as much as 2 years pay for severance. So it's something else to look at. But certainly the human rights issue is there as well. And I encourage you, if you're in BC, come talk to me about it, or one of my colleagues if you're in another province, because it sounds like there's at least a severance issue there and a potential human rights claim. So hopefully that answers the question, Helen, but feel free to follow up. Got more questions. One from Sloan, on long-term disability for almost 3 years due to mental health reasons. You're back at work now, but you're unable to work from the office. Your employer is refusing to accommodate this and demanding their return to the physical workplace. Can you refuse? So Sloan, I've dealt with, unfortunately, a few situations similar to yours. The answer is always, it depends on your job and it depends on the workplace, right? And who your employer, what industry your employer is in. Right. So if you're a laborer, right, or if there's some which you say you're working in the office, you're not a laborer, but if you're a laborer and you have to go in, obviously that's not something that can be accommodated most of the times. If you're an office worker and there's no reason for you to go in to meet clients, or attend certain meetings in person, in my view, that's a reasonable accommodation. Right? Like if you work in HR and your job is just kind of managing payroll or the occasional meeting, I don't see why it would be, I don't see why they wouldn't let you just work from home and just go in maybe occasionally for the mandatory meetings or things you need to go in person for. And so Sloan, I think the answer is, if you're an office worker, depending on the nature of your job, you can probably say no. I say probably because there's a lot of facts I don't know about your case, but it sounds to me that your employer is failing to accommodate to your disability, right? Which is a legal obligation. They're refusing to accommodate you to the point of undue hardship, which is another legal standard that's been set. And so I think, talk to a lawyer first, Sloan, but my inclination is that you can refuse, right? Unless there's some compelling reason that they need you in the office to do your job, right? And so, and it depends on why your reason for being unable to work from the office, right? Like if it's, and whether that's supported by your medical doctors. So there's a lot of factors at play here, Sloan, but to me, if you're an office worker, it sounds like it's most of the times it's probably reasonable to ask to work from home. But again, there's a lot of facts I don't know about your situation. Okay, we've got another question here. You're currently working with us. You're awaiting the draft letter. You have an extremely strong harassment case. I believe a judge would issue punitive damages. Do I have the power option to request that we go further or that the demand letter be unacceptable for my employer if I do not wish to attend the court? So Jay, it sounds like you have, I don't think it's me, but one of my colleagues is helping you. I don't want to, especially because we can't talk about things in this public forum. So my suggestion to you would be reach out to the colleague, one of my colleagues who's helping you, and you and them could have a private conversation. Obviously, with harassment and being fired on parental leave, some of these factors do come into get taken into account sometimes when you're talking about aggravated or punitive damages, right? If an employer is unduly harsh, or for lack of better words, if they're just really mean during the process of termination, right? They walk you out in front of everybody in public. They yell at you and call you names during the termination meeting. They pressure you to sign off on a severance package during the termination meeting. Um, all of these things have been taken into consideration. And you bring up harassment, but yeah, I mean, harassment is it's mostly a work safe issue, but I've certainly seen cases where that comes into light in a civil proceeding, right? And if the company knew about the harassment, didn't do anything about the harassment, and just let it go on, that could be something that a court looks at in determining what are these called extra contractual damages. And so, yeah, hopefully that helps. Jay, I don't want to get into it too much because we are in a public forum here. So guys, I think that's all the questions that we've had. Again, I'm sorry that I came on a bit late because of the technology difficulties. My colleague Dan is on, I believe, tomorrow. I'll be back every 2 weeks. And hopefully if I missed your question, you'll come back and I'll do my best. My contact should be on the screen, or you can go to employmentlawyers.ca if you want to contact me, if you have any follow-up questions, or if you want just some legal advice on your situation. But yeah, thanks everybody for hanging in there and coming. Yeah, I wish everybody happy New Year's, and I'll see everybody in 2 weeks.